It's very satisfying to help people. I just can't imagine a better job.
We are live. Thank you, everyone. Thank you for joining. I'm Michael Ettinger from Ettinger Law Firm. This is our Zoom site chat, one of a series of 6. Today we're going to be talking about the components of an elder law estate plan. So I want to thank you for joining. For those of you who are new, I'm the principal of Ettinger Law Firm. We have been practicing elder law estate planning for 31 years, and we have prepared over 30,000 estate plans and filed over 4,000 Medicaid cases. So I think we have a good handle on the types of mistakes people make and how to avoid them. So today I'm going to be sharing with you what's involved in an elder law estate plan. I cannot take questions while I'm giving the presentation simply because it interrupts everybody else's train of thought. We do have that little Q&A button at the bottom of your screen. If you have a question, please go ahead, type it in, and we'll do a live question and answer session at the end. For those of you who don't know, I'm the author of the book Elder Law Estate Planning, been a bestseller since we first published it in 2010. It's been revised a few times since then. But of course, not everybody wants to read a whole book or has time. So as my thank you for joining us today, we'll send you the abbreviated version, which is the 4-color e-booklet, comes by email, and it's called Elder Law Estate Planning in a Nutshell. It's kind of highlights version of the book, and you should get just about everything you need from the e-booklet. You're welcome to share the presentation. You'll get a recording later this afternoon. You're welcome to share with friends and family as well as my e-booklet. So let's go to the slides now. I'm going to share my screen, put up the slides. Now, you may not realize this, but you did get a copy of these slides with your confirmation for the seminar, so you do have them somewhere at home. So this is one of a series of Zoom side chats. There I am in the middle. To my left, my lovely wife-in-law partner, Suzanne Ettinger, a number of other lawyers and support staff all in the picture. Ettinger Law Firm, limited to elder law estate planning, which is trust and estates, wills and probate, estate tax saving strategies, Medicaid, Medicaid applications, Medicaid trusts. We have offices 2 in Nassau, Lake Success and Rockville Center, 3 in Suffolk, we're in Melville, we're in Huntington, and we're in Bohemia. We're in Brooklyn, down in Cadman Plaza, Staten Island, 900 South Avenue, near the Hilton Garden. Westchester, 140 Main Street, White Plains. Rockland County, we were in Nyack, moved to New City a few months ago. We're in New City. Orange County, we're in Middletown. Dutchess County, we're in Fishkill and Rhinebeck. Albany, we're on Wolf Road, and Saratoga right on Broadway. So let's go right into it. Okay, we're going to start with a revocable living trust, and I'm going to introduce what that is. A trust has parties, the grantors and the trustees. The grantors are the people who create the trust. The trustees are the people who manage the trust. They don't have to be the same person, but in a revocable trust, they usually are the same persons. The people who create it are competent, and they name themselves as trustees, managers of the trust. And then, as we'll see, they name successor trustees and the like. We don't put the social security numbers on the trust, but the trust uses the grantor's social security number. So many years ago now, when revocable trust became popular, which is the beginning of my practice of elder law, I was a litigation attorney for 10 years, 11 years actually, from 80 to 91. Late 1990s when I got involved in estate planning. But in the 31 years that I've been doing it, quite early, the IRS issued a ruling that said if you have a revocable trust, it's not reportable to the IRS because you could take it out at any time. So they consider it still yours. So they say on all the trust assets, use your social security number, don't report the trust as a separate taxpayer. So there's no tax return for a revocable living trust where the grantor and the trustee are the same person, which is most of them. In the document, you will have your addresses. Email addresses are useful, and telephone numbers. So that's the basic introduction to the document. You'll have the name of the trust. And the next thing you'll have is the trustee succession. And the first thing is, who is going to decide incapacity? We like to make it easy. We're practical attorneys here at Ettinger Law Firm. We like to do things that work in practice. We're not tied up in theory. So what's practical is for you to name people that you trust. You can name two of them tacked together, but name the people you trust to decide if you're unable to handle your legal and financial affairs. And all they need to do is get a letter from your doctor saying mom or dad or both are unable to handle their legal and financial affairs. Not that hard to get that letter if and when the time occurs. And then they can, with that letter alone, they can come to us. We prepare an affidavit. We say that mom and dad were the initial trustees per the attached MD's letters. They're no longer able to act as trustees under the terms of the trust. Son Bobby is the trustee, and he has accepted the trusteeship, and he is now acting as the trustee. We contact all the institutions that hold your investments. We say, take mom or dad name off the investment and put Bobby's name on. He's the current trustee. The investment doesn't change, just the name on the title, the name of the trustee. So make it very simple and practical. We like things that work in the real world. But when deciding on the trustee, and again, I like to say that 90% of the job is social work. It's very important to know that it's social work, because if you don't know it's social work, you're doing legal work and it doesn't work socially. And unfortunately, law school teaches lawyers to think like lawyers first and people second. So they do things that work legally and not socially. I don't think that's correct. I think that lawyers should be trained to think about the social implications and have the law follow the social. It should work socially first, and the law should serve the social. So when you're determining trustees, here's an example. You want to have a discussion with a client about the family dynamics. Who gets along with whom? This is going to make all the difference between whether the thing works or not, or whether you're going to have a litigation. Who's capable? You might have a son or daughter who's a financial advisor. You might have another one who's a medical professional. Maybe the medical professional will be best to handle the health proxy, living will, and maybe the financial professional to handle the legal and financial side. And then who lives nearby? While you can pick somebody in Seattle to be your healthcare agent, it might be more advisable to pick somebody who can get to see you, who can make their own assessment of the nature and extent of your situation, talk to doctors in person. Although, you know, in our new world with Zoom, a lot more can be done than before. So we may be shifting. In fact, we may be in the middle of a shift, and it may be that people will be more comfortable naming sons and daughters in far off places because, you know, with these consultations with the doctor by Zoom, maybe they don't have to be in person. So that may be changing. But we want to consider who lives nearby in terms of not necessarily medical. You're in a hospital making medical decisions, but you're at home, you need care. And you want somebody to be able to check on you and see if your caregivers are doing the job and seeing what you need personally and if your situation is comfortable. So that's going to make a difference. And never overlook the fact that you may have a son or daughter who is influenced by somebody else. In fact, I had somebody, my client today, she only has one daughter. Her daughter is, who she told me, is completely in control of her son-in-law, and she came to see me because she wants to make sure that nothing ever gets to son-in-law who she really doesn't like at all. So I told her, well, actually, that's not your biggest problem. Your biggest problem is you have your daughter's backup trustee, and because he controls her, if you become incapacitated, he's going to handle your affairs in the event of incapacity. So she thought her daughter was her agent, and legally her daughter is her agent, but socially her son-in-law is the agent. So I explained that to her and I said, what do you think about that? And she was horrified. She said, I never thought of that. I said, okay, so we're going to have to come up with another plan, because when you pick your daughter, you're really getting your son-in-law. So this is another example of where you have to understand the social so that the legal works. The other thing is, you know, and I had to explain to her, well, one of the things she said is, I want to send my daughter $2,000 a month because she wants to prevent the son-in-law from getting it. I said, well, as soon as your daughter gets a $2,000 check, she's going to give it to him. She said, that's right. So I said, you're actually sending him $2,000 a month. So again, we had to have a discussion. She may end up picking the lawyers here at Ettinger Law Firm as the trustees because we can see to it that the money is only spent on the daughter for the daughter's benefit, and the husband who controls her never gets his hands on it. And furthermore, in the event she becomes incapacitated, she has the lawyers here. The son-in-law is actually making the daughter move to Georgia, and the daughter doesn't even want to move to Georgia, but he controls her, and off she goes. So her daughter will not be able to help her in any event if she needs care at home. So let's have a nice discussion with the client about the family dynamics, talk about who takes over for legal, medical, financial, and how they take over. As I said, I like to make it easy. They just have to get a letter from the doctor. If your treating physician says you're unable to handle your legal and financial affairs, that really should be sufficient, because who's taking over? People you already trust. If you want additional protection, name 2 people, require them to act together. For those of you who just joined us, we have a Q&A button at the bottom. I can't take questions during the webinar, but I'm happy to answer all those questions at the end. Okay? Okay. And we'll get back to that later. Okay? Now, what about revoking a trust or undoing it? Well, revocable trusts are very flexible. You can take anything out at any time. You can put anything in at any time. You can change the trustees and the order of trustees. You can change who you leave it to, the shares of the people you leave it to. You can amend the trust. You can revoke the trust. So you can do anything you want with a revocable living trust. What about on your death, your debts and taxes? They may, but they're not required to pay your debts and taxes. If they have no other source, they can go into the trust, but they don't have to. You can't pay required debts and taxes to be paid out of IRA or 401k money. That violates IRA rules, because it may be more than you're permitted to take. What about personal effects? So we have what's called a blanket assignment of personal effects. So the trust says, I hereby assign or put all my personal effects into the trust. Then what happens? The trust says that the trustee can distribute those personal effects as the trustee decides. But we have something called a memorandum of personal effects, where you can write in which heirlooms, special items, jewelry, furniture goes to which of the children. There's a lovely china that actually none of the children want these days, but there it is. So you can specify, you can say this piece of jewelry goes to this granddaughter and this goes to that granddaughter. And the nice thing about the memorandum of personal effects, it's a side letter. It's not in the trust. It's an attachment to the trust. So you can change it any time without going to the lawyer and changing the trust. But whatever memorandum is there at the end of the day, that's the one that they'll honor. What about the distributions? Okay, look at this happy family. First, you start with your specific request. A specific request is a fixed dollar amount, $10,000 to this person, $15,000 to that charity, etc. Followed by what we call the residuary, where the rest of the estate goes. And you say all the rest, the remainder of my estate distributed as follows, and you have percentages. So it has to add up to 100%, or you have a default there. But generally, you want to treat people of equal degree equally. So one of the things we do at Ettinger Law Firm, let me go back a second here. There are 2 types of lawyers. We say, there's those that will take down the client's wishes and those that will counsel the client. And the lawyer that just takes down the client wishes, we call a scribe. Anybody can write down what you want, but somebody has to counsel you to tell you, well, this may not be practical. This is going to hurt people's feelings. This is going to cause a problem in your family. You generally will want to try to treat people in the equal degree equally, if at all possible. If you're doing something different, we're going to interview and ask you why, and we'll see if there's a good reason for it. Sometimes we'll have a client, for example, that has a son. We'll say he's a hedge fund manager making a couple $1 million a year, and another son who's a massage therapist. So, and they're thinking about maybe leaving more to the massage therapist. I say, well, you know, in a case like that, why don't you do something called a soft probe? A soft probe. A soft probe is you meet with the hedge fund son and you say, you know, we're doing our estate plan. We're thinking leaving your brother Jeffrey more, maybe leaving the whole thing. You kind of float out the idea and you look for a reaction, and you will get a reaction. The son will say, well, I don't think that's fair. I think it should be 50-50. Or he'll say, I don't need it. Leave it all to my brother. I don't care. So this way you've cleared it, and, there's not going to be ill will in the family. So consider the soft probe if you're leaving unequal shares. And it works quite well. Now we want to talk about the very tricky problem of a house for a surviving spouse in a second marriage. So I have seen many, many plans over the years that says, and this is the standard that lawyers use, they say, I leave my wife the right to live in my house for her lifetime. And if she sells the house, the money goes half to her and half to my children. Well, this puts the wife on the horns of a dilemma. If husband dies and she finds the house is too much to handle, if she sells the house, she only gets half the money, may not be enough to buy a condo or another place. If she keeps the house, she's in a place where she doesn't want to be and managing a house that is too much for her to handle. So we don't like to put the wife, it could be the husband, of course, in this dilemma. So what we do is we say the wife has the right to live in the house, but she can also substitute the property. So let's say the house is worth $1 million and she substitutes it. She has the right to sell the house and buy a condo for $500,000. What happens to the other $500,000? It stays in the trust. She gets the income for life, and on death, the house and the $500,000, we call it the substituted property, goes according to the terms of the document, whatever the parties have agreed. So we like the spouse to have the right to substitute the property, might use all the money for another property, might use some of the money. The difference gets invested, they get the income from. This works in the real world much better than the other formula. And as I said, things don't have to be equal. We have an expression in estate planning. We say there's nothing so unequal as the equal treatment of unequals. Let's say that one more time. There's nothing so unequal as the equal treatment of unequals. It doesn't have to be equal, but if it's not, we want to make sure things get smoothed over so it's not a surprise to somebody at the end of the day. Of course, some people have estranged children. They want to leave them $1 or $100. Somebody told them that you have to leave them something or they could challenge. That rule is from the 1950s. If you're leaving, don't leave somebody a small amount. First of all, we have to find them, give it to them, and it's very insulting. We say, if you're going to leave somebody a small amount, you're better off not to leave them anything at all, because it's a bigger insult to leave somebody a smaller amount than to leave them out. People can deal with leaving them out. They have a lot of trouble being left a pittance because it stirs the whole thing up. So we want to be practical about that. Charities, we don't necessarily want to leave a percentage to a charity because they can call for an accounting of the whole estate to see if all the bills were, paid and everything was done according to Hoyle. And maybe your family doesn't want to do an accounting for the benefit of the charity. So leave them a fixed amount, 25,000, 10,000, 15,000, whatever it is. So charities, specific bequests. Again, if you have a question, we're going along, just type it in and we'll do the Q&A at the end. You go to the bottom of your screen and type in your question. We put in a defense for challenges. Okay, if you leave somebody, you're leaving somebody out, or you leave them less than they think they're entitled to, we have an interorum clause that says that if you challenge my trust, you lose the share. Okay, so this could be a disincentive. If you leave somebody, sometimes clients will want to disincentivize one heir from suing. So they'll say, I leave 50 or 100,000 to so-and-so because if they sue and they lose the 50 or 100,000. So that's going to be a disincentive to them because New York honors the interorum clause. So that's going to generally scare them off. Do you know that it's much harder to challenge a trust than a will? I did a paper on this once, and maybe I'll explain it a little bit for the benefit of our listeners today. To challenge a will is the easiest thing in the world because In a will, it gets filed in court and everybody gets a notice. The will's been filed to probate. Basically, you know, all you have to do is check a box and say you don't agree. And that starts a will contest. And, you know, will contests are often settled in favor of the illegitimate heir. And the reason for that is because it's in court and the legitimate heirs cannot get their share until the case is settled. Well, they want their money now. So they say, okay, well, how much will it take for you to go away? And they'll often challenge because otherwise you could be tied up for years in a court proceeding. The reason trusts are much harder to challenge is because it's not in court. So the disgruntled heir, first of all, they don't know how much you had or who you left it to because there's no public record like there is with a will. A will, they can see how much there was and who was left it, who got and who didn't get. With the trust, they don't see that. So now they have to hire a lawyer. First, they have to find out what was in the trust, but they can't stop. There's no court proceeding. They have to initiate a court proceeding. And remember, the trustee has already distributed the assets, so now they have to run after everybody personally. You know, it's a lot harder to run after the money when it's been distributed than like a will before it's been distributed. A lot of lawyers don't want to take on a challenge to a trust, first of all, because trusts are harder to challenge. The courts feel that if you set up a trust, it was a more sophisticated instrument than a will. You probably knew what you were doing. So lawyers don't like to challenge them. And then they have the problem of running after the heirs and finding the assets, which is, again, a real challenge. So if you want to leave somebody out or you want to leave them less than they think they're entitled to, set up a trust. They won't get any notice. There's no court proceeding. And they don't know how much you had or who you left it to. So that makes it much more difficult. What about trustee succession? Well, you know, in the trust, generally in the revocable trust, you're in charge. You name your successor trustees. Generally, one or more of the adult children, but of course, not everybody has children. It could be nieces, nephews. Some people don't have anybody. They pick the attorneys here at Ettinger Law Firm, which we're happy to help out. And you can have an option. You could say my last name successor can appoint a successor. If you don't, again, it's the lawyers here. We're the default. We act as backup trustees if everybody fails, but you can pick whoever you want in front of us. Then we have trustee voting rights. So you have two trustees. You have an option. You could say they have to act together or they can act individually, like a joint account. Either can act. And there's pros and cons of both, but we try to encourage the ability to act separately because it's more flexible, it's more practical. Now, if you have two trustees and they act separately, they still have to notify the other of what they're doing, but they don't have to get their signature. They don't have to both appear in the bank at the same time. And, you know, they can also share the duties. One can do this and the other can do that. So more flexibility, more practicality, works better if they can act separately. But some people need the security requiring them to act together, and that's a possibility as well. The trustee's bond. So our trusts generally do not require the trustee to post a bond because it's an expense and it's a challenge, but you can have them post a bond. The bond is to guarantee a monetary guarantee of that they will perform their duty and discharge their obligations. And if not, the bond will pay the damages. Liability of the trustee. Well, generally we say they're not liable for mistakes or errors of judgment, only for willful misconduct. In law, willful misconduct is a nice way of saying stealing. We throw in a HIPAA authorization that allows them to get your medical records, very important to help determine the nature and extent of any cognitive decline you might be going through, to determine when it's necessary to take over. What about underage and incapacitated heirs? So you left it to your son or daughter, but unfortunately, they predeceased you. It goes to their children. We generally at Ettinger Law Firm, based on our experience, will hold it in trust for the children until they're 35. Usually a brother or sister, which is an uncle or aunt, is in charge, can use the money under the trust for their health, education, maintenance, and support. Whatever they don't use, they turn over at age 35. You can pick another age. Why did we pick 35? Well, when I started, as I said, 31 years ago, we used the age 25. Over the years, we found 25 is too young, and for another couple of decades, we raised it to age 30. And now in the last 5 years, we've had to raise it to 35. This is based on our experience with our clients and with people. It seems as life expectancies have increased dramatically, in my career, in the last 40 years, life experiences have increased dramatically. It seems the longer people live, the slower they are to mature. So we have found that sometimes 30 is too young. Now, if they're ready before 30, the trustee can give them the money. But if they're not ready, they can hold it back until they're 35 or whatever age you choose. Remember, the trustee can still use the money for the heirs, can use it for their health, education, maintenance, support. They can give them all the money before 35 if they feel ready. But again, if they don't feel they're ready, they can hold it back. If they're incapacitated, unable to handle their affairs for any reason, the trustee can pay it to their guardian or caregiver. And actually, we have a provision in our trust that if the trustee determines that they're unable to handle it even at 35, there are some provisions that allow the trustee to hold it back if they need to. The spendthrift provision. What's the spendthrift provision? Well, let's say son dies and it goes to grandson. And at 25 years old, somebody approaches the grandson, or the grandson approaches somebody and says, I have this trust, I'm getting this money at 35. If you give me 50 cents on the dollar, I'll assign my interest in the trust to you. This prevents them from selling, assigning, pledging their interest in the trust. The spendthrift provision, they can't make a deal like that. In an estate plan, you have a pour-over will. What's that? Well, it does two things. Because it's a later will, by law, it cancels an earlier will because you don't want another set of instructions floating around out there. And it does something else. It says, in case I left something out of my trust, pour it in there after I'm gone. How does this occur? Well, you are very careful. You put your assets in the trust. The assets not in the trust will have a beneficiary or they're joint. So that if you die, it goes to named beneficiary or the joint owner. But there are some examples where even that doesn't help. For example, we find sometimes client dies and their brother or sister's estate, which they left to them or a portion to them, is stuck in probate for a couple of years. The probate never got completed. So now the money comes after they passed. Well, this pour-over will catch it and put it to the trust. We want to try to avoid it because, as you might glean, the pour-over will has to be probated. What if the client dies in a car accident? The other driver is responsible. Now the client's estate comes into money damages. You're not there to put it in. The pour-over will catch it, add it to the trust, distribute it according to the terms of the trust. Again, if you have any questions, hit the Q&A button at the bottom. We'll do the Q&A session at the end. Now we have something called the elder law power of attorney. Not all powers of attorney are created equal. People come into my office regularly and they say, oh, I have a power of attorney, I'm all set, and they put it down on my desk and it's 4 or 5 pages. Say, well, this elder law power of attorney is actually 14 pages. What do you think's on those other 9 or 10 pages? All the powers you need if someone becomes disabled. They're elder law powers done by elder law attorneys because we know what's needed in the event of disability. That's the area we deal with. So I call the standard form power of attorney that most lawyers use, I call it over-the-counter medicine. This elder law power of attorney is prescription strength. And it works just like medicine. What if you need a prescription strength and you only have over-the-counter medicine? You know what happens? It doesn't work. It's not strong enough. Same thing with the power of attorney. If you become disabled, the standard form will not have the powers you need to move and protect assets. The key power of which is something called the unlimited gifting power. So imagine this. The standard form power of attorney allows gifts up to $500 per year. If you're going to a nursing facility and I can only move $500 a year out of your name, well, you're going to lose it all to the facility. We have an unlimited gifting power because we know, and there's a chapter in my book on this, we know we can save half of your money even on the nursing home doorstep. If you want to know more about this, you can go to my website, trustlaw.com, 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 and look under practice areas. I wrote an article on protecting assets on the nursing home doorstep. I can always save half the assets provided I could move it out of mom's name. So mom's going to nursing home tomorrow. She has $700,000 in assets. If I have the power to move $350,000, half the money, I could save it by gifting it to the kids. If I have the standard form power of attorney, I can't do it. If I have the Ettinger elder law power of attorney, it has the unlimited gifting power. I can save $350,000 by moving it to the children, have the power to move it. We can move it tax-free. So you want an elder law power of attorney. I can't even apply for Medicaid benefits without an elder law power of attorney. And if you wait, if you only get the standard form and then the client becomes disabled, it's too late. You can't get the elder law power of attorney. So once you reach your 60s plus, you really, in my view, need to see an elder law attorney. You may want to change beneficiaries. What if you have an IRA or a big insurance policy going to a spouse who's in a nursing facility? Well, what's going to happen. It's all going to go to the nursing facility. We need to be able to fix that. We need to be able to create a trust for you, sometimes an irrevocable trust, sometimes revocable. We may need to modify the trust. Now, these are extraordinary powers. They're very powerful. But again, because we're a practical law firm and we put the social in front of the legal, we feel don't protect and a lot of lawyers do this. They protect the client from their own family. I say, don't protect yourself from your family. Pick the right people and give them all the powers. I'll give an example of most lawyers, what I'm talking about. Most lawyers will create a power of attorney and they'll say, I pick my spouse first and my daughter or son second. Seems to make perfect sense. Yeah, of course. Who would argue with that? But yes, I want my spouse first and my daughter second. We don't do that at Ettinger Law Firm. At Ettinger Law Firm, we say, I pick my spouse or my daughter. Why do we do it that way? Because lawyers try to protect you from your children. It's safer, my spouse first, my daughter second. But what happens in the real world? Here's what happens. Very often, when I need to use that power of attorney, a dad is elderly. He might be needing to go into a nursing facility. But lo and behold, mom is also elderly. And sometimes she doesn't have her cognitive abilities. She may be suffering from dementia, Alzheimer's, Parkinson's, some other cognitive disability, and she can't act. But I can't get the daughter. The daughter can't act unless she can prove mom can't. How do you prove that? Well, you have to get the doctor to write a letter. Will the doctor write the letter? Will it be clear and unequivocal? Will the third party accept the letter? And you have to deal with this for every asset and every account. And very often it doesn't work. So you trust your daughter? Of course you do. Otherwise you wouldn't have named her. So I say, wife or daughter. Now, if daughter needs to use it, she can just go ahead and use it. There's no hoops to go through. So again, be practical, pick the right people, give them all the powers. If you want extra protection, you can name two people, require them to act together. My son and daughter have to act together, although I don't recommend it. It's a possibility. Now they're going to be able to act in the event of disability. Who makes medical decisions? There's your healthcare proxy living will. Well, you make all your own medical decisions, but the healthcare proxy takes effect when a doctor determines in your chart that you're unable to make medical decisions for yourself. And now the power of your agent comes in. I said how it's triggered. The doctor indicates you're unable. And the agent can make any medical decision except one. They can't make a decision to terminate life support unless they can prove this is what you actually wanted. How do they prove it? Well, they have a living will that says that and you signed it, it says if there's no hope of recovery and I have no meaningful existence, I authorize my agent to withhold life-sustaining treatments like feeding tubes, artificial nutrition, hydration, ventilation, electroshock therapy. You can sign a DNR, do not resuscitate. The agent can on your behalf. In New York, you can only pick one agent at a time. So you have a primary and a backup. The reason for that is if you pick two agents and they don't agree, the doctor wouldn't know what to do. So they can all discuss it amongst themselves, but the doctor is only going to pay attention or listen to the agent named in the document. We have funeral and burial instructions. So in your own handwriting, you will provide on our form what type of service you want, what type of burial, has it been prepaid, who's going to be in charge of the arrangements, and what issues, organs and tissues you may want to donate. Final instructions to your family. Here we have a form for you to fill out, giving your family basic information you need to settle your estate, including if you're married, date and place of marriage, subscriptions that need to be canceled, computer usernames and passwords, very important. Family, friends, businesses, professional advisors who should be contacted to your death, anything you want to include in your obituary. You know, I call this the guide to the perplexed. If you've done all this work, that's going to make it much easier for them. And we have a, let me go back, previous. We also have a checklist, contact Social Security, contact the post office, etc. What about deeds and other asset transfers? We deed your properties to the trust. For a new deed, get a recorded account to return to you. You give us email addresses to your financial advisors. We send them, let me go back. We will send them a copy of the trust on an email, PDF, and we'll ask them to retitle your account to the name of the trust, and we'll copy you on that email and ask you to confirm the instructions to them, and that's how we do it conveniently. We help you change the beneficiaries in your IRAs, annuities, insurance policies, either to the trust, or sometimes to your children's inheritance protection trust, which I'll talk about tomorrow. The Inheritance Protection Trust protects the inheritance you leave from children's divorces, lawsuits, and creditors passed by blood instead of by marriage. I talk about that in my weekly seminar on elder law estate planning tomorrow too. Oh, there it is. Okay, so tomorrow too, I'm going to talk about the 4 advantages of using trust. In there, I'll talk about why we want to avoid probate, avoiding guardianship proceedings if you become disabled, the Inheritance Protection Trust, which I just mentioned, and the famous Medicaid Asset Protection Trust, the one you set up 5 years ahead of time, protects your home and life savings. You register for that at ettingerplan.com. It's Wednesdays at 2 o'clock live, so you can post your questions. But if you're not available, you just register anyway, and you get the recording and you watch later. So you can do that at your convenience. A word about our unique planning process. It's begun with this seminar. We offer a free initial consultation. First thing is we ask you to bring in your health proxy, living will, power of attorney, your will or trust, and we review it and tell you if it's adequate. And I'm looking for, and my lawyers are looking for, is it practical? Is it going to work in the real world? Are there glitches in it? Does it have something like your daughter is backup on the power of attorney? By the way, I meant to mention, you know, you have protection anyway because your daughter doesn't have the power of attorney. You have it, it's in the house. She knows where it is and she comes and gets it if she needs it, but if you have a spouse, she's not going to need it. So you have practical control over it. She doesn't have the document running around with. She only gets it if she needs it. So as I say, we review your existing plan if you have one. We'll give you a free copy of my book, Elder Law Estate Planning, advise you which chapters apply to your situation. At the first meeting, even though we don't do business in the first meeting, you know, we prefer that it's more low key, that everything gets explored and you go home and think about it. But we like to let you know how much you're in for if you decide to go forward. It has nothing to do with the amount of assets you have or the size of your estate. It has to do with what work we're recommending. It goes according to fee schedule. But we just, you know, people like to know where they stand. So we tell you how much it'll cost if you decide to go forward later on. And we ask you to set up a second free follow-up consultation to have your questions answered. Then you come in for the second meeting. We answer any questions you have, either from the first meeting or the chapters in the book. We asked you to read, might be an hour's worth of reading. We draft that estate plan together with you. Now going back, you know, we ask you successor trustee for legal, medical, financial, how do you want the plan distributed all at once over a period of years, equal, unequal, those sorts of things. And we talk about the social aspects of everything, make sure it works socially. Second marriage planning, lots to talk about. Want to make sure the plan works for everybody, keeps the family together. And at the end of that second meeting, we give you a detailed written proposal for the fees quoted. Here's the fees we mentioned last time. Now it's in writing. Here's everything we're going to do for the fee proposed. Say, what would you like to do? A lot of people say, you know, it sounds good. Let's go forward. We've done this for over 30,000 clients in the 31 years we've been around. But here we break with tradition. I believe we're the only firm in the country that does not use a retainer agreement. I analyzed a retainer agreement a number of years ago, And I figured out why lawyers are trained, like myself, I was trained, get a retainer agreement, the client signs, and they give you the retainer. It's usually half the fee. I don't do that because when I analyzed it, I realized that the retainer agreement is designed for the benefit of the lawyer. That's why we're trained to do it that way, but it's not for the benefit of the client because the client has no control. After you sign the agreement, you pay the check. What does the client have? The client doesn't have anything. They have a promise and a hope. Doesn't always work out. They don't always get along with the lawyer, or the lawyer takes too long, or the lawyer didn't get their wishes, but they're trapped. So we don't do that. What we do is we have a fee proposal. We sign it. Our client doesn't sign it. Our proposal says we're going to go ahead and prepare all these documents. You come in for a third meeting. We'll review everything: trust, inheritance trust, health proxy, living will, power of attorney, deeds. After everything is signed, you pay at the end. But unless and until you write us a check or give us your credit card, whichever, you have no obligation to the firm. You can get up and walk away at any time. You don't owe us anything. So what we believe in is putting the client in control. And here's what I consider a breakthrough in legal thinking, which is if we put the client in control from beginning to end, clearly that's the best place for the client to be. And if we're here to serve the client and that's the best place for the client to be, then we think, well, it must be the best place for us to be because that's what we're here for. We're here to serve you. So we have now 30,000 happy clients. So you don't pay anything till it's all done and you're satisfied. And we like doing it that way ourselves. We take credit cards. We prefer checks, so we don't have to pay the credit card company, but some people like the credit card, so we accept it. And you could pay it once at the end, or you could pay it in up to 3 monthly installments, a third, and a third. Now, after the plan is signed, we don't say goodbye. The standard in New York, thank you very much, goodbye. I doubt if anybody listening ever heard from a lawyer prepare their will, but that doesn't work, and we'll see why. We say welcome to the firm. We trademarked the process. I did in Washington in '99 because I wanted an Ettinger plan to work when you need it, not when you wrote it, I hope, decades earlier. So we publish a law letter once a week, and it's one article a week. And anything where the law changes, you'll know about it because you get it through our weekly Ettinger Elder alert, called an alert because it comes by email. Also goes nicely with Ettinger and Elder. And we won an award for it. So I think you'll find that valuable. If you're on this call, you're going to start getting the Elder alert because we got your email, so you'll be added to the list. Here's the key. At Ettinger Law Firm, we offer a free, we don't just offer, we send you a letter every 3 years, time for your free review. Make sure that the plan still makes sense for any changes in your health, your assets, your family, births, deaths, marriage, divorce, etc. So here's how it works. We've been doing it for 22 years. People come after 3 years. Not too many people need a change. Naturally, after 6, but we renew the acquaintance, we catch up. We're building the relationship. I think it's valuable. After 6 years, naturally, more people need a change. But statistically, it's been shown that very few people can get past 9 or 12 years without needing a major change. Who's in charge? Who they're leaving to? Something else happens. So you do an amendment. Now, an amendment, they say, averages once every 10 years. And it's legal work. You pay for that. But we're talking hundreds, not thousands, and you're good to go. The point is, when you go to use an Ettinger plan, it's designed to work when you need it, not when you wrote it, I hope, decades earlier. And we have saved thousands of people, countless thousands of problems. And the nice side effect is when something bad happens to one of our clients, we know who it is because we've seen them within the last 3 years. We don't charge for phone calls. We don't charge for emails. We don't charge for questions because we want you to communicate with us without worried about getting a bill. By using this program, your plan is never more than 3 years old. It works when you need it, hopefully many decades later, not when you signed it. We offer a free consultation. It's a $500 value because a lot of firms charge $500 for the consultation, many of which have less experience than us, but nevertheless, it's still worth $500. It's free. We want to keep you in control. I'll be with myself or Mrs. Ettinger, my law partner, Suzanne, or one of our experienced elder law attorneys. We do not have any inexperienced elder law attorneys. They've all been with us for a long time. And when we hire another lawyer, we only hire experienced ones, and then we train them in the Ettinger way. Consultations are available in the office these days. So many people are vaccinated. Everybody here is vaccinated. So, things are opening up. You should feel more comfortable coming in, and people do. It can be by Zoom. About half of our meetings still by Zoom, and no problem. We're happy to do it. And if you want to bring in somebody who's, in another part of the country, they can come in on the Zoom, or it could be by phone. You'll get an invitation to schedule your own appointment later this afternoon with a copy of this meeting, this Zoom meeting. You'll get our link. It's called Calendly. You pick your own time and make an appointment. You can call our Director of Client Relations for more than 26 years, Patty Brown, the 800 number there. You can email Pat. She can answer any question you have. She's been here for a long time. And you can email her, pbrown@trustlaw.com. You can also text free C for consultation to the number on your screen. And so now I'm going to ask you to hang in there, and we're going to look at our question and answer. So Brandel says, what is community Medicare? How is that structured and implemented? Brandel, it's called community Medicaid. So let me explain the difference between Medicaid and Medicare. Medicare is a government-sponsored health insurance program. As you know, everybody gets at age 65, doesn't matter how rich or poor you are. But Medicare is only for skilled care. That means doctors, nurses, hospitals. Medicaid is for custodial care, help with washing, dressing, toileting, transferring. Now, Medicaid, not everybody gets. It's what's called a needs-based program. You have to need it. So in other words, first you have to be unable to handle any two or more of the activities of daily living. They're called the ADLs, activities of daily living: washing, dressing, toileting, transferring, feeding. If you can't do two more of those, you're eligible for Medicaid, but the other eligibility is economic. If you have your own assets, you have to spend down till you have virtually nothing left. If you're single, you have to spend down to about $16,000. If you're a couple, you have to spend down to between $75,000 and $130,000, depending on a number of circumstances. If you're a couple, the spouse at home can keep somewhere between $75,000 and $130,000. But if you're over that, you have to spend down before you qualify for Medicaid, unless you planned ahead. With Ettinger Law Firm, you sheltered those assets in a properly established Medicaid asset protection trust. They don't count, so you're eligible for Medicaid from day one. Now, to get community Medicaid, today, you can move all your assets out of your name in this month, in April, and on May 1st, you can be eligible for Medicaid. Starting July 1, that's not going to be the case anymore. Starting July 1, they're going to have a 2.5-year look back for Medicaid benefits for home care. And that means you want to get your Medicaid trust in place before July 1. To get community Medicaid, if you have income, we have to send it to a pooled income trust. That's a different subject. There's a chapter on my website about it. There's a chapter in my book, but there's also a chapter on the website on the pooled income trust, how you shelter income to qualify for Medicaid for home care. It's called Community Medicaid. So go onto my website, trustlaw.com, and look at the pooled income trust. It explains it. Anonymous. Can you take money out of a revocable trust? Of course, anytime. You can take whatever you want, whenever you want. I was told if you take possession of money from a trust, it invalidates the trust. Well, there you're talking about a Medicaid asset protection trust, which is an irrevocable trust. And a Medicaid trust, you can only take income. You can't take principal. If you take principal, it invalidates the trust. What's the difference between income and principal? Income is earnings, interest, dividends. Principal is the money itself. You can't take the money itself. But if you watch my seminar tomorrow, I'll tell you how to get your principal out of the Medicaid trust legally. Frank F. says, is the spouse responsible for credit card debts? No, the spouse is not. Anonymous. Ideally, should the power of attorney be the same person as the trustee? Absolutely. Anonymous. You want the same person in charge of the trust money as the money outside the trust. Otherwise, you run into a conflict and all kinds of issues. I mean, it's one person handling all your finances. How does it work if one person is the trustee and another person is the power of attorney? It's very awkward because the trustee is doing one thing, the power of attorney is doing something else. Here at Ettinger Law Firm, we don't, we never allow that because it creates an inherent conflict. It's problematical. If you have that problem, come in and we'll see if we can fix it for you. And one more question from Anonymous. Is spouse responsible for credit card debt? No, as I said, no. unless there's a probate. If there's a probate, the credit card company can file against the probate estate, but not against the trust estate. So the trust, yes, does protect against legal action for credit card debt because there's no probate. Kai Lun says, I have 3 houses. One is mixed commercial. They have the New York Partnership for Long-Term Care, which means once the long-term care insurance policy runs out, New York will only go after your income. They won't go after your assets. It works. A partnership policy works like a Medicaid trust. Very few people have it, but if you have it, it's a good plan. The Cadillac of plans. If you have a partnership policy, yes, you would set up a revocable trust instead of an irrevocable trust because the partnership policy is tantamount to having an irrevocable trust. And the nursing home cannot touch your assets. The partnership prevents that from happening. Anonymous, pour-over will must be probated? No, only probated if there's an asset that wasn't accounted for. So if everything outside the trust has a beneficiary, is joint, there's no probate for the pour-over will, only if it's needed. Is it costly and time-consuming? Yes, we want to try to avoid probate. We'll talk about that in my seminar tomorrow, why we want to do that. Anonymous, do you still need unlimited gifting power if all your money is in an irrevocable trust? Well, no, you wouldn't need it because the trust has the unlimited gifting power inside it if we need that. Here's where we'd use the unlimited gifting power. Let's say you put all your money into the irrevocable trust. Now, we know there's a 5-year look back, but what if you don't make it? What if 2 years later you have to go into a nursing home? Where are you going to get the money to pay for the last 3 years? Well, we can gift the money out of the trust to the kids and they can pay the nursing home for the last 3 years before you're eligible for Medicaid. Hopefully that doesn't happen, but we need to be able to get the money out if you're short of the 5 years. Anonymous, can I put a co-op apartment in a trust which is jointly owned? Yes, but you have to check with your managing agent, the co-op, to see if they allow trusts. Some do, some don't. The better ones do, in my view. Most of them do, but not all of them do. So call your managing agent. Does the co-op permit transfer of your shares in the co-op to the trust? York K says, are there any taxes due when you transfer assets to a revocable trust? No, actually, the trust is tax neutral. Doesn't affect you at all. In fact, it uses your Social Security number and the IRS doesn't get any report. They don't want to hear about your revocable trust because the IRS is still yours. You could take it out at any time. You haven't done anything. No taxable event, no report to the IRS. You file the same income tax returns before. Anonymous, are your fees based on the value of a client's estate? No. It has nothing to do with the size of your estate. It has to do with the work that needs to be done, and it goes according to our fee schedule. My mother is quite elderly, doesn't have a lot of money, but needs planning. Well, we have some flexibility. So come in and talk to us. The consultation is free. We'll see if we can work something out. Anonymous, are there any cons of moving all your assets into an irrevocable trust? Well, irrevocable trust is income only. So you don't move all your assets into it. You move the assets that you're not going to spend, like your home. Assets, maybe you're just reinvesting, you don't need it to live on because you have enough income. Assets, you're only taking the income from, but not spending the principal because the trust gives you the income. So we talk about that in the consultation. But Anonymous, if you have a nest egg that you don't need to live on, you're actually safe keeping it for the nursing home industry. So why not put in the trust? Still there if you need it through the gifting power to your kids, but somebody else can't come and take it away from you. So we'll talk about that more in the consultation. So I want to thank you all for joining me today and for listening to what I've had to say. And I hope you'll follow up and make an appointment to see us in the office because that's really where the rubber meets the road. That's where you actually get some of the benefits of having a plan done. And I think you'll be very happy if you choose Ettinger Law Firm. So thank you for listening. Wish you all a good afternoon and hope to see you soon. Thank you.